Good morning. Today is Thursday morning, December the 10th, 2020. This is John Richardson speaking with you from Toronto, Canada. One more of my series of podcasts of interest to Americans abroad, green card holders, citizenship aficionados, etc. And today is actually a very special podcast because yesterday, a group of accidental Americans has filed a lawsuit against the U.S. State Department, arguing that the $2,350 U.S., yes, you heard right, a $2,350 fee for permission to renounce U.S. citizenship is unconstitutional. And that lawsuit, although organized, I suppose, by the Association of Accidental Americans based in Paris, is spearheaded by Mr. Marc Zell, an international lawyer based in Jerusalem with offices all around the world. And it is my distinct privilege and honor to speak with him today from Jerusalem. Good morning, Marc. How are you?
John, great to be with you today.
Likewise. Okay, amazingly, the fee to become a U.S. citizen is like $680 with all that research and all that vetting. And I think there's some kind of a biometric fee as well, bringing it into the $700-something range, as far as I understand. Yet they are charging people $2,350. In the case of accidental Americans, people who in many cases didn't even know they were Americans. Some of them don't even speak English. $2,350 to not be a U.S. citizen anymore. I think everybody would agree that it's unfair and outrageous, but your job is to explain why it's unconstitutional. So can we start with the 30,000-foot view of this, and then we'll get into the weeds.
Right. Well, Thomas Jefferson, John, indicated way back in the 18th century, as the U.S. Republic was being founded, that the right of a citizen to expatriate, to dissociate himself or herself from his society is a fundamental natural right, from which many of the other, in fact, all of the other fundamental rights that are protected by natural law and by the Constitution derive. And so it's interesting that this particular right, the right to expatriate, has never really been adjudicated in the federal court, certainly by the Supreme Court. And our case will be the first one in which we're going to be arguing that this is a fundamental right protected by the U.S. Constitution. And why is that significant? It's significant because, according to the Supreme Court, when you're talking about other fundamental rights, like the right of due process or the right of free speech or the freedom of the press, when those rights are regulated, when the government attempts to regulate or abridge those rights in some fashion, the courts will determine whether the constitutionality of that government regulation under what's called a strict scrutiny analysis. What does that mean? That means that the government attempt to abridge a fundamental right, remember we're saying that expatriation is such a right, the government attempt to regulate that right would only be sustained under the Constitution under a strict scrutiny analysis if the government can show, one, that they have a compelling reason to do so, and two, even if they have a compelling reason, that the regulation or the action taken by the government to regulate that fundamental right is narrowly tailored to achieve that compelling interest. That is the heart and soul of our case, John, and that's one that we hope that to be able to elucidate for the first time in American legal history.
All right. Well, this is incredible. And as I said earlier, when I read the complaint, first of all, I congratulate you on doing a superb job. And I encourage anybody interested in the law of citizenship to actually read this. It's an amazingly well-documented chronology of this stuff. But let's break this down into the things that you're talking about. The fundamental right, the test that the government has to meet if it's a fundamental right, and the issue of narrowly tailored. But in any case, let's back up for a minute, and I'd like to just add something here. You know, I've done a lot of reading over the years on this whole citizenship thing, and I do agree with you that the notion of expatriation is at the heart, actually, of the American identity and the sort of evolution of law in America. But what I find interesting about it is that it's primarily been the right of people coming to America to expatriate. That's what's interesting about it. And the idea that people might want to expatriate from America is not only a new concept, but it is something that people are doing in a context where the whole law of expatriation, frankly, has revolved around the U.S. trying to strip people of their citizenship rather than people trying to voluntarily de-citizenshipize themselves. So let's back up a little bit here. And I wonder if you could elaborate a little more on why you think expatriation is a fundamental right.
Well, first of all, you're absolutely right, John. Most of the focus on this issue has taken place has taken in the context of foreigners coming to the United States and being able to expatriate from their places of origin after becoming immigrants to the United States and becoming naturalized U.S. citizens. That really was the focus primarily in the 19th century. You know, when we had these large migrations of people, including my own family, from from Europe and other places into the United States. Some of the European countries, which were abiding by a kind of an ancient tradition that once you owe allegiance to a sovereign, you do so for all eternity. They took the position that Americans, people coming to the United States and becoming American citizens, were still subject to, for example, conscription under foreign draft laws and that kind of thing. The Russian Empire, for example, took that position with many immigrants to the United States. And the American government said, no, this is something that we will not tolerate. Once they become American citizens, they have a right to dissociate themselves from the countries of their birth or former allegiance. We will recognize that. What our case is doing is putting the kind of the shoe on the other foot, and I think you're absolutely correct about that. When Congress actually in 1868, which is a significant time frame in American history, because this is the time that your listeners may know when this whole panoply of civil rights legislation, including constitutional amendments, were being adopted by the United States Congress and became part of the United States Constitution to protect things like citizenship. You know, in the 14th Amendment, as you know, that the Section 1 of the 14th Amendment says specifically that persons who are born in the United States are entitled to be treated as citizens. I'm paraphrasing a little bit, and their citizenship, as you know, their citizenship as U.S. citizens will also make them citizens of the state in which they reside. So, or they were born in, or they reside in, I guess is the right word. That legislation, the 14th Amendment, the 15th Amendment that had to do with the right to vote, notwithstanding the racial origins of the voter, and the 1868 law passed by Congress, which specifically said that the right to expatriate is a natural right and enjoyed by all American citizens, and did not distinguish, by the way, between whether the shoe was on the one foot or the other. The right to expatriate applied to, under the law, applied to an American who was naturalized and Americans who were accidental Americans too, by like the plaintiffs in our case. And that's what's really coming up now. Really, the other important question, I'm sure you're going to ask me about it, is is why now? Why has this become an issue here in the early days of the 21st century? I mean, this
Well,
has been
help us
talked
with
about
that.
for 200 years. Okay.
Consider the question asked.
All right. And the answer, it has to do with a statute with which you are very familiar, John. And it's called the Foreign Account Tax Compliance Act, which was passed in 2010 and basically took effect for all intents and purposes in 2012. That 2010 date is very important because it's also the year, within days of the passage of the FATCA, we call it, okay, this act that requires, and you can describe the act better than I can, but it put this enormous burden on Americans residing abroad to turn over huge amounts of their private information to financial information to the U.S. government and U.S. government force the hands of foreign governments to actually enact American tax law as part of their domestic law in order to force banks and other financial institutions to comply with this law and to violate the privacy rights of American citizens and other U.S. persons living abroad. This was a radical departure in American law, particularly American tax law, and it came the same year, for the first time in the history of the United States, John, that the United States State Department charged any fee for the right to renunciate, the right to expatriate. That fee was fixed in 2010 at $450. And within about 4 years, I guess, 4 to 5 years, they jacked that fee up 5 times at the current rate of $2,350. Now, it wasn't an accident in our view that the rate that the U.S. government was charging this exorbitant fee, any fee, for renouncing citizenship at the same year, the same month, frankly, that FATCA was adopted. And that's because, and they say it, the State Department said it, okay, we expect, as a result of this FATCA law, that the number of Americans renouncing the citizenship will rise significantly. And they tried to use that as a basis for slapping on a fee. But because that happened, because in fact, and they were right, when people began to understand, Americans abroad, including the accidental Americans, as you said, many of whom didn't even know they were American citizens until FATCA was enacted. And how did they find out, John? They went to their bank one day, and the bank told them, listen, you're not welcome here. You know, you may be a customer here for years, but you're no longer welcome to keep your bank account in our bank. And these accidental Americans said, why? Because we found out that you are a U.S. citizen. And we don't want to be bothered with all the headaches to try to comply with U.S. tax law that the FATCA legislation imposes upon us by virtue of these agreements that our country has entered into with the United States Internal Revenue Service. So get out of here. You have a mortgage? Too bad. We're calling it in. You can't get it. You want a line of credit for your business? Forget it. You're not going to get it. You're a U.S. person. You're a U.S. citizen. And we don't want to be bothered with U.S. tax law obligations and all the bureaucracy and headaches that go with that. We made a decision just to cut all the U.S. citizens out of the bank. And when this happened, I mean, this was a shock to thousands, if not millions, of Americans living abroad who didn't know they were Americans to begin with, and then found out, in one fell swoop that they were subject to all of these prohibitions and requirements. And even in those countries like in Israel, where I am, that didn't throw you out of the bank, but made your life miserable, just to be able to open a bank account or keep your bank account. So people began to say, what do I need this for? Okay, I'm talking about people that didn't really, we call them accidental Americans. They didn't really have much of a connection to the United States at all, except for the fortuity of the fact that they were born there, And they said, okay, we want to renounce. So they went in and they wanted to renounce. And every one of them said, we're doing it because of this FATCA. Some of them had other reasons for renouncing, which we don't have to get into here. But that's it. We want out. We want out. Please let us out. And then
Mark,
they find it.
would you say that? I mean, great description, but I'm wondering if we couldn't sort of summarize it in this way: the advent of FATCA and the discovery of the citizenship and dealing with these problems has really put these people in a situation where, frankly, they're forced to renounce U.S. citizenship if they want to continue on living their normal life. Would you agree with that?
Absolutely agree. We say
So
that.
then we have a situation where they are essentially forcing them to renounce on the one hand, and on the other hand, jacking up the fee to $2,350.
But a lot of people, they say it in our complaint, just they can't afford it. They can't afford to renounce their citizenship. So it's like they're in a catch-22 situation. On the one hand, as you say, they're being forced to renounce because of all these FATCA-related prohibitions, and their ability just to live, to conduct their ordinary financial life in these countries. And on the other hand, they're told that in order to get out, they've got to pay this exorbitant fee. It really is mind-boggling.
It is mine. I mean, I have seen, for example, GoFundMe campaigns, out there, people trying to raise the funds. And another interesting aspect of this is that, what does $2,350 mean? Well, it depends on what the exchange rate is and what your local currency is.
That's also true. And a lot of these people, especially today, when we have the pandemic and you're not able to work at all, in a lot of these countries, even before the pandemic, their economies were going south. So people were out of jobs, and they, it's unfair. It's inhumane. John, it's unconstitutional.
I agree with you completely. And, on behalf of all these people and myself, I mean, I think, the research you've done has been such an important contribution to this. I thank you for the work that you've done on this. Seems to me when I read your complaint, it's only 66 pages. And I say, it's amazing that you've condensed that much in such a readable format. But I think that, we've got three things we're talking about here. Is first of all, the right to renounce, which belongs to the individual. You acknowledge in your complaint that the government has the statutory right to make the rules for renunciation or for expatriation. That's the second issue. But the fee thing, as you point out, is quite interesting because that is not something that, and I hadn't never thought about this, but thank you for putting it in there, is not something that's mandated by the statute at all. This is just coming from sort of a general regulation that says that these government departments can, charge fees that bear some relation to cost, et cetera. And, frankly, I mean, if I were on the receiving end of that complaint, I would be frankly embarrassed by the behavior of the U.S. government. I would be embarrassed. Yeah. I mean, I would be surprised if this even sees the light of day. I think they would be so quick. To
Let's
roll.
Hope you're right. Let's hope you're right.
Well, would you want to defend this?
Well, no, and you're not certainly not under these circumstances, but maybe these are government attorneys. They got a job to do, and they will be, and they're going to be putting up a fight. Believe me, they will.
Yeah, I think they will put up a fight, but I think that they're going to embarrass themselves because the problem is that for a judge to rule against you, it seems to me the judge has to rule that expatriation is not a fundamental right.
But I do respect the right of my fellow American citizens, even the accidental Americans, and particularly them, to exercise this right. That's something that kind of goes without saying, and that's why I'm honored to pursue this. I just want to say one other thing before we go too much further. I don't want the listeners to think that this complaint was only my sole doing. I had the very essential and extraordinary assistance of my colleague Noam Schreiber, who recently became, he's been an Israeli lawyer for a number of years and recently became a member of the New York Bar. And I really want to thank him also for all of his hard work and research on this complaint.
Yeah, it's absolutely fantastic work. What would you expect the timeline on this to be? And by the way, I would like to actually add, sort of in addition to your comment of being a proud American citizen, I think it's important to realize that this lawsuit is a contribution to the value of American citizenship.
There you go.
First and foremost, absolutely. This is not about in any way, shape, or form denigrating U.S. citizenship, or it's actually, I think, an important enhancement in the same way that, the seminal cases of Forium and Vance versus Therese, these cases are. And I wonder, I noticed that you cited both those cases in the factum. Do you understand a case like a Forium to mean that to reinforce the right of expatriation?
Well, we think it necessarily follows from those cases. Just so the listeners understand, Forium and Therese were cases in which the State Department attempted to cancel the U.S. citizenship of persons who had engaged in acts which U.S. law said were incompatible with their U.S. citizenship status. Okay, in the case of Ephraim, I think it was serving in the Israeli army, and that's an issue that we've come up with, had to confront personally here. But those cases needed to, for the first time, really begin to plumb the idea of what is citizenship? What is this right of citizenship? It's never really defined in the Constitution. It's mentioned, as I said, in the 14th Amendment, but it's never really defined. And the courts have had a difficult time, theoretically, wrestling with this concept. What does this mean? And in those cases, the Supreme Court said quite properly that American citizenship is a fundamental right. Okay, I think they said that, and you can't go around canceling it willy-nilly. You need to make sure that the person who you are attempting to denaturalize did this voluntarily, and you need to go through the steps to ascertain that fact. And that's why the State Department, for instance, was trying to use the kind of examination that they have to do in those non-voluntary renunciation cases to justify putting on the fee in the voluntary renunciation case. But you know what was really weird? The really weird thing is that before they imposed a fee, or this $2,350 fee for voluntary renunciation, they had already were charging a lesser fee for the non-voluntary renunciation, where they had to do actual real work. So the whole thing just is really nonsensical. But those cases are really the bedrock upon which our case is going to be based in the converse. I mean, that's what we're going to be looking at now.
Right. So the idea, I think would be simply this, that the citizenship, certainly the United States is actually, if not the only country, one of the few countries in the world that has a constitutionally guaranteed right of citizenship in the 14th Amendment, at least for people born or naturalized in the United States.
Right.
So I suppose the argument is that if the citizenship belongs to the individual, then the individual can decide whether he wants it or not. In other words, what the point is, the citizenship doesn't come from the government.
That's correct.
So it's not the government's to take away.
It's a natural. Well, okay. Now we're getting into the esoterica. Okay, so, and that's one of the interesting things we had to struggle with in drafting this complaint. What is the source of citizenship? Well, it is what the society says it is, right? It's not something that comes necessarily from on high. although there is a basis for talking about when a person, the natural right of a person to be a citizen in the country in which he was born in, or where his parents were citizens, and by blood. These are concepts that really haven't been adequately dealt with, even in the American Constitution. That's why, for example, and the listeners may recall that there's a lot with all of the controversy about these dreamers on the DACA statute. That were born, people that were born or in the United States to illegal immigrants who came to the United States simply to have their children there in order to make them U.S. citizens. And the president, Trump, wanted to do something about that. That's obviously an abuse of this rule of citizenship that the 14th Amendment seems to embrace. He wanted to do it by an executive order or by statute even. And I'm not sure how that works, because the citizenship is something that has its roots in the Constitution and maybe even predates some of the ideas in the Constitution, as does the right to denaturalize voluntarily, to expatriate. They go hand in hand. One is the kind of the flip side of the other coin, of the same coin. So that's something we're dealing with, and it's fascinating. How the courts are going to deal with this, God knows. But we're going to make them. Our task is to bring that issue squarely in front of them, perhaps for the first time. So they have to decide now: what is a U.S. citizen? What is how do you become a U.S. citizen, and how you relinquish your U.S. citizenship voluntarily? Right. Yeah, that's what our case is about.
Well, that's why this is such a tremendous contribution to, the literature, the legal concept of what citizenship actually is. So as we come to the end here, though, to move it back to what the complaint actually says, you've got 4 or 5 specific grounds. And if you can just kind of, for the listeners, go over those. I think, for example, one of them is it violates the Administrative Procedure Act. We have First Amendment due process, excessive fines. I think those are the ones, aren't they?
And we have a case under customary international law. Yes. Okay. Yeah, you've given them all, John. That's really good. You probably did better than I would do.
Well, that's a testament to how well it was written.
Okay, thank you. And Noam, thanks you too. What I want to say, look, I think our opposition may stumble across your podcast, so I have to be careful what I say here. I think all of the constitutional claims we made here, and we have one statutory claim you mentioned under the Administrative Procedure Act. All of these are very substantial claims, and I don't want to rank one against the other, but there are a couple that really kind of stand out and hit you between the eyes. One is what we call the substantive due process claim, which says, when the government, this is where we started off our conversation today, John, when a government tries to curtail a fundamental right guaranteed by the Constitution, it needs to meet the strict scrutiny standard and show a compelling interest and a means that's narrowly tailored to the result. And that is the core claim here. We also have a First Amendment claim. What is this? A lot of our litigants, plaintiffs in this case, are saying, listen, I don't agree with the United States. I don't want to be part of the United States. I mean, I don't agree with them, John, quite honestly. I have a different view. But they're entitled to it. They're entitled to their views.
That's what part of being an American is the right to think what you want and dissent.
That's right. And the point you made is an excellent one. That this case, even though it's talking about renouncing American citizenship, this case is really about reinforcing and helping to revitalize what it is to be an American. That actually it strengthens American citizenship and the rights that an American citizen has under our Constitution. That was a very, very profound observation that you made, John, and I thank you for that, because it's definitely true. And that's why I'm proud that we filed this case, and we're proud to pursue it wherever the judicial system and our constitutional frame of government takes us. Okay.
Yeah. Well, this is absolutely fascinating. I know it's impossible to predict time frames and that kind of stuff. You know, not knowing enough about the procedure, the court procedure in that particular court, what's happening is that this is not a live trial, right? This is going to be decided based on the written material.
Well, that's an interesting question. I have to be careful what I say here too, because our case is not, if it was brought solely under the Administrative Procedure Act, I would agree with you. Okay, that's the rules of the court require, and the cases that are brought under that act, that they basically are resolved on the papers without any kind of a trial. But as you know, John, in any part of a regular civil case, there is, particularly in the United States, a very extensive period of discovery. Okay,
right?
Because after the government, in our case, files its answer, and there'll be a motion to dismiss the case, I'm certain, and then file it, and if we succeed in an answer, after that, the parties are able to conduct discovery. They can take depositions, they can request documents. In our case, one of the things that we're going to be looking at is to get into what happened at the State Department when they first imposed a fee back in 2010 and later jacked it up 5 times in 2015. So we want to get into that, and in our case, we want to conduct that discovery. I believe we're entitled to conduct that discovery under the constitutional counts that we have in our complaint. So that's going to happen. Now, we can also get to a point where there may be some fact-finding involved after we complete discovery, and that may be appropriate for a jury case, for example.
Wow. That would be an amazing spectacle. A case like this unfolding in front of a jury in America. I mean, I can't even imagine it.
Well, that's something we're going to be addressing, but it's going to be whatever procedural context it proceeds in. I can say that it's going to be, the issues here are fundamental. I'm sorry to use that word. They're profound. They're important for all Americans. They're important for us to decide, to help us decide what is the meaning of American citizenship to those of us who are proud natural-born Americans or naturalized Americans, and for those who feel that they want to sever their ties with the United States, particularly in the face of this kind of overreaching, in my view, that the American Congress and the American government engaged in when they enacted FATCA and this related regulation. So that's something that we need to make sure to bring forth in these courts, in the United States District Court for the District of Columbia, in the DC Circuit Court of Appeals, if it gets that far, and possibly even in the United States Supreme Court.
Wow, absolutely amazing. I think it's worth pointing out for listeners that the plaintiffs in this case, and correct me if I'm wrong, but the plaintiffs in this case are in fact citizens of other countries who reside in those other countries, who are subject to full worldwide taxation or whatever those other countries have, and are really just trying to live their lives as citizens and residents of those other countries without interference, essentially, from the United States.
Precisely, that is true, and that is why these people, when if they prevail here and we get rid of this unconstitutional fee, will go on and be able to lead their lives in an ordinary fashion without having to be subject to all these restrictions that natural-born and naturalized Americans living in the United States don't have to contend with.
Yeah, it's like two different systems of taxation and regulation. The United States imposed a completely different tax system in effect on people who live outside the United States and the regulatory problems. But
now, our case is not a tax case.
Without that, people have the right to expatriate.
That's right. We're not. Our case is not a tax case. That's important to state. It's a case about the right to expatriate, as you stated. And I have to also indicate that I went back and I just wanted to remind myself. I see we didn't ask for a jury trial in the case, so we may have to consider that too in light of our conversation here today.
Go for it. Go for it. I mean, I just, what a oh my God, what a spectacle. What a spectacle.
That would be
all right,
terrible.
Marc, I want to thank you, 1, for the podcast, 2, for the tremendous work you've done in putting the complaint together, 3, for what I predict will be a tremendous contribution to the understanding and evolution of the meaning of American citizenship. In fact,
thank you, John.
It's, I think that, I know that you're a highly respected, well-known lawyer, and by me, I highly respect you and know you well.
Mutual.
Okay. But this may be the case that becomes a memory of you in the legal profession over all these fine years.
Yeah, well, it's an honor to be associated with the Association of American Accidental Americans, with Fabian Laharge and all these extraordinary plaintiffs, and of course my colleague Noam Schreiber. So.
Yeah, well, I think also, as I said earlier, I think that the claim should probably be, worked into, a scholarly article, because what's that saying? When the student is ready, the teacher arrives. Okay. And the time has come for the teacher to arrive, and that's what you've done here. So, Marc, thank you so much for all of these things. It's been a real pleasure speaking with you today. Great
to be with you, John. God bless you. And if I may, from the capital of Israel, Jerusalem, happy Hanukkah to you and your listeners, those of you observing.
Thank you, Marc.
Bye-bye.